Attorney Paul Clement, the former U.S. Solicitor General, is arguing the Loper Bright case for the plaintiffs at the High Court. He joins us now to further discuss the implications a decision in this case might have. Paul, it's great to have you back. It's been a while. The structure of the American government is built on this system of checks and balances, and those supporting the fisheries in the Loper Bright case, you will argue, they say that federal agencies are abusing their power. But do we want non-experts making decisions on what drugs are legalized or what new rules will come out of an agency?
Well, Montse, it's great to be with you. And I think you have to be careful about sort of accepting the idea that the people making these decisions in the agencies are so-called experts. I mean, I don't think it really takes any great scientific or technical expertise to say that, well, we don't have enough money here at this agency, so we're going to make the fishermen pay for the monitoring services. I mean, that's a classic decision that really has nothing to do with science or technology and has everything to do with political accountability. And our framers thought about these issues. They wanted the taxing and appropriations power all to be in the Congress. They want to have an agency that can make so many regulations that it couldn't actually afford to enforce all of them without making the regulated parties pay for additional federal monitors.
Now, Paul, you're talking about money in terms of fees, but cases like this have come up in the past where you're talking about fines for not complying with regulations, like the case of the Little Sisters of the Poor or the case of the transgender mandate. Are these also the exact same situation of regulations that are made by agencies that don't have subject matter expertise?
I think so. And even if they have some claim to subject matter expertise, they certainly don't have political accountability, and they don't necessarily have the kind of expertise that takes the balance and interests of other people into account. So Little Sisters case, which obviously I'm familiar with, is a perfect example because there all Congress passed was a women's health mandate. Well, that's easy for Congress to pass. Who's against women's health? But they left it to the agencies to decide how to fill out the details of the mandate. And those agencies are the ones that decided that all 20 forms of FDA-approved contraception have to be covered in every employee plan, including in every employer plan, including the Little Sisters. Now, that's a decision where you might think that HHS and FDA have some expertise about the drugs or the contraception, but what they have no expertise in is how to make accommodations for religious exercise. And I have a lot of confidence myself that if instead of allowing Congress to just get away with this vague women's health mandate, that Congress itself had to get to the level of saying, all right, contraceptions are going to be provided as part of these plans. I think the law might not have passed in the first instance because it would have been so controversial. But if it did pass, I'm pretty sure that Congress would have worked out a compromise that would have accommodated the religious interests of the Little Sisters and other groups like that. So I think there are real costs to allowing the politically accountable Congress to kick some of these issues to agencies that are not politically accountable.
So in this case, we're talking about fishermen. Are they unique, or are small businesses affected by these government agencies in other ways or exclusively affected by agency regulations?
So I don't think the fishermen are unique. I think they're a perfect encapsulation of how the administrative state in Washington can end up regulating not just, you talk about the Chevron doctrine, you think about big multinational corporations. But in reality, a lot of the people who are subject to very costly federal regulations are small business people in a variety of different industries where things that I think the framers would have thought are left best to local government are being regulated by the federal government, and not by Congress, but by these agencies. And the small business people in particular really don't have the resources to try to go to these agencies, get the ear of people in these agencies, participate in the so-called notice and comment process. That's easy enough if you're a big multinational corporation. But if you're a herring fisherman or other small business, that's not really a process that's open to you.
Now, there are many who say that this will ruin the government's ability to keep Americans safe. What do you tell them?
Well, I say, really, do you really think that our Congress people don't care about safety? I mean, of course they care about safety. And there are areas where the federal government should be regulating, where Congress should make clear what the rules are about safety. And there are other areas where I think the framers was designed to have state and local governments responsible for safety. You know, some of these issues are best dealt with at a nationwide level, but a lot of these issues are best dealt with at the state and local level. And the advantage that essentially everything other than an administrative agency at the federal level has is it's just easier for people to make people accountable for their decisions.
Do you think, Paul, then, that Congress, as divided as it is right now, would be able to do some of what you've outlined, is giving them more power and more forcing them to do more work, basically, a good idea?
I actually think it is. I mean, I know that may sound counterintuitive to some people, but think about the dynamic we have right now, which is Congress is, you know, it goes back and forth whether the Republicans or the Democrats are in control, but it's always closely divided. And at any one point in time, roughly half the people in Congress have their friends of the same party running the the executive branch in all those administrative agencies. So why would they ever make a compromise when they can get their friends in the executive branch to get them exactly what they want? And what that does is it leads right to the kind of paralysis we see. There's no incentive to come to a compromise that's going to be enduring across one administration versus the other. Instead, there are all these incentives to basically say, I'm going to just kick this can down the road. I'm going to leave things vague because at least right now, my friends in the executive branch can fill it out. And then the law will change every 4 years. That's not what the framers had in mind.
Not to be at the whim of political power, where, Paul, we will be watching this closely and look forward to argument before the court. Thank you so much for being with us.
My pleasure. Take care.